Good morning, everyone. Welcome to the Board of Liquor License Commissioners for Baltimore City's May 20th, 2021 virtual hearing. My name is Nicholas Blendy. I'm the Deputy Executive Secretary of the Liquor Board, and I will be your disembodied voice for the day. Well, actually, my body is on the screen. So briefly, I want to go over some instructions so that attendees and members of the public understand how we're going to run the virtual hearing today. We operate on the Cisco WebEx platform, much like the Board of Estimates, City Council, and Planning Department have been using since the outbreak of COVID-19. In order to fully utilize WebEx, members need access to a laptop or some smart or similar device that has camera and microphone capabilities. If you do not have microphone capabilities on your video device, then you'll need to use the phone number to dial in order to be heard. It's at the bottom there. In order to participate, members of the public need to have downloaded the app and can access the link that is available on our slide right here and also on our website. We suggest that if you're going to use your smart device, that you download it and test it at least a day before the hearing, and that you have a backup computer in the event that yours, as mine did, decides to crash right before the hearing. If any member of the general public doesn't have an access to a computer or a similar device, as I mentioned, that number and access code are at the bottom of the slide. Materials and evidence for today's docket, copies of the short docket and the long docket are all found on our website under hyperlinks for May 20th, 2021. During the COVID virtual rule hearings, the board is observing a 48-hour rule for evidence. So any evidence to be considered today is in the long docket and must have been submitted to our Assistant Executive Secretary by 11 a.m. Tuesday, May 18th. Licensees should make any effort to always provide documentation they wish to show by observing that 48-hour rule. And in addition, every licensee has been served with the appropriate notice according to the requirements of law. The procedure for today's docket, starting by the preliminary reading of instructions, which is right now, and then I will be calling the cases. The chair will, as they appear on your docket, the chair will then ask the licensee or his or her representative and any and all personnel to identify themselves and be sworn by our court reporter. Then the board conducts an evidentiary hearing. I call the case. Witnesses can be called, testimony can be given, and any documents that have been entered into the record will be reviewed. And that will determine or guide the board in determining whether a violation has occurred. Upon the conclusion of the hearing, which can include closing arguments by a licensee or their rep, the board will then vote to determine whether or not a violation occurred. If the board finds a violation, then they may hear testimony or review evidence before imposing a sentence. And the board can provide, at the close of testimony, the board will provide an opportunity to members of the general public to present testimony, the mitigation phase of the hearing. And how that will operate is if an individual does want to testify, I will ask them to use the raise your hand feature on the WebEx platform, and then you'll be recognized. You can identify yourself, and then you must be sworn in and testify. Anybody who is testifying today is subject to questioning by the board and cross-examination by the attorney or the licensee. Remember, if you have access only to a phone, you cannot testify, as we have to have video footage of you. Upon the conclusion of hearing evidence and testimony in the mitigation phase, the board would then make a sentencing determination, which can include either a fine, suspension, and or revocation of the license. Finally, general Grail rules. Please mute yourself when you're not speaking to minimize feedback and extra noise. We ask that you clearly identify yourself, and if the court reporter needs the spelling of your name, state before you speak. We ask that you speak slowly and in a clear voice so that our court reporter understands what is being said and who is saying it. And please note this event is running live on Charm TV and that a court reporter is present. Any individual who uses profanity, is disrespectful or unruly, may be expelled from the hearing. All attendees, applicants, licensees, and members of the public who wish to provide testimony must be sworn, as I mentioned earlier. We are taking no physical evidence at these proceedings, and no amendments to any applications can be made at this time. Helpful virtual reminders. Please be prepared and have. Who's that? Please be prepared and have read ahead of time the materials and test your video conferencing platform. Try to be in a quiet place with good light and strong internet connection so you can be seen and heard clearly. We ask that you be present and not be multitasking. And please, as always, be patient with yourself, with others, and with technology that throws us fun curveballs every hearing, it seems. But with all that, short docket is up, Mr. Chairman. Do commissioners have any questions, or should I call the first case?
Let's proceed.
I believe Mr. Fogelman is representing and has moved into the panel. The first case on today's docket, Anthony L. Cushing and Anna C. Cushing, Cat's Eye Limited, or LTD, trading as Cat's Eye Pub, 1730 Thames Street. Licensee holds a Class BD7 beer, wine, and liquor license, and licensee is alleged to have violated 4 rules of the Board of Liquor License Commissioners, 2 stemming from an incident on April 17th, 2021, a violation of Rule 4.16 illegal conduct, and a violation of Rule 3.12 general welfare, and 2 violations stemming from an incident on April 24th, 2021, violation of Rule 4.16 illegal conduct and Rule 3.12 general welfare. Mr. Fogelman is counsel, and he should be in the room, Mr. Chairman.
Good morning.
Good morning. Will you identify yourself for the record, please?
Thank you, Your Honor. Stephen W. Fogelman on behalf of licensees.
Good morning. Will these be admissions or denials?
Just a little bit of confusion. I'll set it up for 2 denials and the rest admissions, specifically denying the illegal conduct 4.16 violation of March 17th, 2021, and denial of the 3.12 general welfare charge also of the same date.
Mr. Chairman, there are no violations charged from March 17th. That is just in the narrative. There are
Okay.
violations charged for April 17th and April 24th.
Well, that makes this easier. I will enter a general admission.
Okay. Yeah, there was just a warning issued on March 17th, but no violation.
Right, and that's why I wasn't sure if it was for the narrative or was to, or was an additional charge. So we're grateful for that. Always grateful for a warning. Yes, and,
right.
this will be an admission to the other dates.
All right. Well, then, do you want to just provide an explanation, or does your client want to?
I can run through this pretty quickly, although this one's a little more complicated than the others. First of all, you had, and I know that the inspections division can back this up, but you had an unprecedented number of calls and visits by the agency. I mean, over 100 calls, 311 complaints about this establishment. They do believe it was a customer who had been banned from the place, who had actually threatened to do as much. And they reported to me that the liquor board or other agencies visited them sometimes more than 10 times in a single day, which is, I mean, I've never heard of such a thing in my years of doing this. And somebody, one of the inspectors, says somebody must have it out for you. So that having been said, on the dates that are charged, indeed there were overcapacity issues. They are doing everything they can now to make sure this never happens again. So now they understand it's 50% all the time. Okay, so we all know the confusion that the licensees have had with the multiple executive orders that have been issued and the various interpretations of it. But this bar is an even bigger Rubik's Cube because you have a rear outdoor courtyard, an interior bar, out front dining, and live entertainment. So by rights, the licensees think that now that we've loosened these restrictions, this is for current, times, that they could have 100% in their outdoor courtyard. But because there's live entertainment inside, they're sticking to 50% because they don't want to violate any more executive orders. But it's just kind of a challenge that this poses. They got rid of some old bar stools during the original lockdown in March of 2020. They had not replaced those bar stools when the bar was allowed to reopen. They do not have a high-risk food permit, so they've been closed practically more than they've been opened over the last year. They now have had $800 worth of new bar stools delivered, and they have, Ms. Cushing had a meeting with security staff to help them overcome the security staff's confusion on what the capacity is. And now the whole place is 50%. So she's also, like I say, ordered these bar stools and had them put in because there were allegations that people were walking around without a mask on. So that will not happen again. There are seats for every customer within that reduced capacity. And she's met with the serving staff, and it's a no tolerance policy. Your mask's on if you're walking to the bathroom, if you're walking out, if you're seated and you're drinking, then you take it off. Additionally, she's re-implementing a covered charge to slow capacity into the bar on popular nights like Friday and Saturday nights. Trying to think if there's anything else I ought to say. It's just obviously it's been a bad year, and they recognize the seriousness of the allegations. It's a venerable establishment, and I hope you will.
6 years.
46 years? Wow, that's almost as old as me. So I would ask that you consider a fine, and I thank you very much.
Thank you.
For the record, I just want to note that Ms. Cushing is correct. They've been in business since 1975, and I only have a record of one violation back in 2008. So the record has been good up to this. Do commissioners have questions?
I have none.
No questions.
Okay. Mr. Fogelman, anything further?
No, thank you for your time.
Thank you so much.
You're welcome. On the basis of the materials contained in the charging documents, the proffers from counsel, and the admissions as to these violations, I find Rule 4.16 violations on both April 17 of this year and April 24 of this year, and Rule 3.12 general welfare violations on those same dates, April 17 and April 24, 2021. And in light of the record and the explanation and the remedial measures, I would impose fines of $50 as to each violation for a total of $200 and give them 30 days to pay.
Thank you so much.
Commissioners?
Commissioner Guy, based upon the evidence presented in a proffer from Mr. Fogelman, I would also find violation of Rule 4.16 illegal conduct and Rule 3.12 general welfare on April 17th, and violation of Rule 4.16 illegal conduct and violation of Rule 3.12 general welfare, which took place on April the 24th, and I concur with a fine of $50 for each offense payable in 30 days.
Thank you.
Based upon the charging document and the proffer for Mr. Fogelman, I too find a violation of Rule 4.16 on April 17th and April 24th. I also find a violation of Rule 3.12 on April 17th and April 24th, and concur with the imposition of a $50 fine for each.
Mr. Blendy, before we make it final, was there any public comment?
If any member of the public wishes to testify on this matter before the board, please use the raise your hand feature in the WebEx platform. Mr. Chairman, I do not see any member of the public who wishes to testify.
Okay, so then that sanction of $200 total will stand, 30 days to pay. Ms. Russell, do we have exhibits?
Yes, I'd like to call exhibits for the record. Exhibit number 1, violation report, Inspector Tudhope, dated 4/17/21. Exhibit number 2, violation report, Agent Perez, dated 4/24/21. Exhibit number 3, Mayor's Executive Order, dated 3/12/21. Exhibit number 4, Mayor's Executive Order, dated 3/26/21. Exhibit number 5, Service Request Summary Report, dated 4/17/21. Exhibit number 6, Service Request Summary Report, dated 4/24/21. And exhibit number 7, BLC Guidance, dated 3/25/21.
Thank you, and thank you, everyone.
Thank you, Your Honor. Thank you, Commissioners.
Thank you very much.
That concludes this matter before the board. Licensee will receive follow-up via mail with instructions on how to pay your penalty.
Okay,
Miss-
immediately.
Mr. Chairman, are you ready for the next case?
Yes, sir.
The next case before the board this morning, licensee Thomas W. Hamrick and Yanis Carolina Silva, Carolina Tex-Mex Restaurant, LLC, trading as Carolina Tex-Mex Restaurant, 500 South Wolf Street, 21231. Licensee holds a Class B beer, wine, and liquor license, and licensee is alleged to have violated 3 rules of the BLLC stemming from the same incident on March 19th, 2021. Licensee is alleged to have violated Rule 4.14, live entertainment without authorization, Rule 4.16, illegal conduct, and Rule 3.12, general welfare. Licensee is represented by Mr. Previs, who should be in the panel, Mr. Chairman.
Okay. Mr. Previs, would you identify yourself for the record, please?
Good morning, Mr. Chairman, members of the board. Peter Previs on behalf of the licensees. To my immediate left is Mr. Pedro Silva, one of the owners of the establishment, and off screen is his manager that was on duty that evening, Ms. Mayra, M-A-Y-R-A, Bernal, B-E-R-N-A-L.
And will these be admissions or denials?
A lot of the facts would be admitted to, Mr. Chairman, but I think it's just going to be easier and more expedient if I just deny all 3 at this point.
Okay. So is it Agent Perez and Agent Han, are they going to be testifying for the board?
I will testify, Chairman.
Okay. Let's swear Agent Perez and swear Mr. Previs's witnesses.
Raise your right hands, guys.
Okay, please raise your right hand. Okay, do you solemnly swear or affirm that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury? And please state your name before your response.
Agent Perez, I do.
Pedro Silva, I do.
Mayra Bernal, I do.
All right, thank you. Agent Perez, do you want to tell us what happened on March 19th, please?
Yes, sir. On March 19, 2021, approximately 10:21 p.m., 311 call number 21-00208137 was received for loud music at Carolina Tex-Mex, located at 500 South Wolf Street. On approximately 10:45 p.m., I, Agent Perez, along Agent Han, responded to the establishment. Upon arrival, I heard loud music emanating from the second floor bar. I was able to hear the music across the street at the northwest corner of South Wolf and Eastern Avenue. After making this observation, I proceeded to the interior of the second floor bar through a stair door located on the Eastern Avenue side of the building. Once inside the establishment, to my right, I observed approximately 3 individuals unmasked, playing pool and consuming alcoholic beverages. And to my left was a DJ set up with turntables, mixer, and amplified speakers, playing music that was causing a disturbance outside. Furthermore, a group of approximately 8 individuals was observed dancing to the music being played. After making this observation, I made contact with the night manager, Ms. Mayra Bernard, and made her aware of the complaint and violations observed. While speaking to Ms. Bernard, I was approached by an unidentified white male who apologized for the loud music and explained to me that he had rented a portion of the venue to host a birthday party. He further stated that he brought in a DJ to play music, unaware that the establishment didn't have live entertainment privileges. I explained that this was the responsibility of the establishment management to abide by the rules and regulations of the liquor board, not his. At this time, the DJ ceased playing music and individuals drinking while standing were instructed to go back to their tables by the establishment management.
So they were generally cooperative, Agent Perez?
Yes, sir.
Okay. Mr. Previs, do you have questions for the agent?
Thank you. Agent Perez, when you arrived at the outside of the restaurant, you said you could hear music. Did you have a sound meter?
I did not.
Okay. Did you provide a warning to the establishment prior to issuing a citation for
On
loud
previous
music?
occasion, this is not the first loud music violation that I have issued for this establishment.
So your answer is you did not on this occasion?
Not for this incident specifically.
Okay. How do you, what standard do you use to determine whether music is too loud?
If I can hear it at the nearest residence.
I'm sorry.
I determined that the music was loud because I could hear it at the nearest residence.
At the nearest residence?
Yes.
Okay. And at what level of hearing it does it turn into a violation?
When it becomes a disturbance.
And what facts did you use to determine that it became a disturbance?
When I could hear it across the street from the establishment, several feet away.
That sounds a little circular. So the fact that you could hear it at any level is your determination that it's a disturbance?
No, sir. When I can clearly hear the lyrics of the song bass shaking outside of the building, that was my determination of loud music.
Okay, and you heard bass, you felt bass shaking
Yes.
in this case?
Yes.
Okay, all right. With regard to the DJ, what did you observe?
Full DJ setup, turntables, mixers, loudspeakers connected to that, amplifiers, and a designated.
I'm sorry, I didn't understand the last thing. You said amplifiers?
Amplifier connected to the speakers. Yes, sir.
Okay, all right, and you heard music coming from this setup?
Yes.
And what, if any, persons were around this equipment?
Repeat the question, please.
Were there any persons on or around this equipment that you just described?
There was one individual designated playing music from that equipment setup.
And what was he doing when you first? I'm sorry, I didn't mean to cut you off. I'm sorry.
There were about 8 people that were dancing to this music were standing about 10, 15 feet away from this table setup.
Okay, and what was the individual doing?
He was pushing buttons out of the mixing equipment, earphones over his ear. Just what you
Okay, and
typically see a DJ doing.
Did he have a microphone?
I did not witness a microphone, sir.
Thank you. Okay. Now, with regard to your part of your violations is for COVID violations of the mayor's executive order of March 12th. Is that correct?
I don't remember the exact day of the order. Don't have it in front of me right now.
I can refresh your recollection. The attachment to the liquor board packet indicates a mayor's executive order dated March 12, 2021. Is that what you're relying on? Okay.
I don't have it in front of me.
So, okay. What, you didn't cite a violation for exceeding occupancy percentage capacities, is that correct?
No, because I couldn't determine the exact capacity for the second floor. The whole building is designated as an assembly of 150 individuals. That's including first and second floor. So at that time, I wasn't able to determine exact capacity for the space being used.
And you saw about 11 plus staff?
More about, yes, there were a few people in the bar,
Okay,
not more than 5.
okay. All right, and so what was it in the mayor's executive order that was being violated?
The mask order was in violation
Okay,
while consuming. I mean, you either have to be seated consuming or without consumption standing with a mask on.
okay, so the 3 individuals playing pool had their masks down?
Yes,
And the 8 individuals that appeared to be dancing, did they have their masks on?
no mask, drinks on their hands.
Okay. You didn't observe anybody being served anything, is that correct?
I do not recall.
Okay. All righty. I have no further questions. Thank you very much.
Welcome.
All right, do you wish to present evidence or what?
I just very briefly, I would like to ask Ms. Bernal to explain what was her state of mind that evening. She's going to be assisted with interpretation by Mr. Silva, if that's okay with the board.
Fine.
Okay. State your full name.
Yes. Mayra Bernal. Mayra?
Okay, and you were the manager on duty on this evening?
Yeah. Yes.
Okay, and you spoke to Agent Perez?
Hablaste con Mr. Pérez. Sí. Yes.
Okay, and did you notice that the individuals at the pool table had their masks down?
¿Te diste cuenta que tenía la máscara puesta en los que estaban en el billar, sí o no? Sí, tenía. Yeah, they have a mask.
Okay, and they did or did not?
They did? Yes.
They did. What about the 8 individuals dancing? Did you notice 8 individuals dancing?
Los 8 que estaban bailando tenían la máscara, sí o no? La tenían abajo. They have it down.
They had it down.
Okay.
Okay, and you agree that they should have had their masks up?
¿Tú estás de acuerdo que tenían la máscara? Sí.
Okay, and now the music.
Oh, and it's hard to
What-
hear the responses. Sorry, this is the
Keep your
reporter.
voice up,
It's hard
okay?
to
Come
hear the
closer.
response.
Thank you. We'll try to get closer. I'm sorry. All right. Now the music. Was there a DJ performing or was there just music playing?
Estaban haciendo un DJ, estaba jugando la música, solo estaban jugando música. Solo poniendo música. Solo poniendo, just play music.
Just play music?
Yeah. And
Okay.
he have something to say. She asked Mr. Perez if it's okay to dance, and he said yes.
Okay.
That's my.
Él me dijo que podían bailar
He
solo
said-
con la
He
máscara.
said yes, they can dance with the mask on.
With the mask on?
Mhm.
Okay. So it's your understanding that dancing was okay as long as the mask was on?
Yeah.
Okay. But if they pulled the mask down, that was not proper.
Y lo ponían abajo así, no era-
No.
Okay. I have no further questions of Ms. Bernal unless the board has questions of her.
Commissioners, I don't.
Commissioner Guy, I have no questions.
No questions.
Okay. I have no other questions or witnesses.
You want to
I'd
be
like
heard?
to be heard. Yes, sir. Yes, Mr. Chairman. Okay. With regard to the live entertainment charge of 4.14, I've made this argument previously. It's 2 things. One is if the charge is for dancing, the dancing that's included in the definitions of live entertainment, both in the city code and in the liquor board rule, is a dance performance, not individuals dancing. And that is from the case of Rojas versus Board of Liquor License Commissioners for Baltimore City, 230 Maryland App 472, 2016. In that the board conceded in that reported opinion that dancing, according to the definition of live entertainment, was a dancing performance and not individuals dancing. With regard to the DJ, I don't think it's sufficient evidence that the DJ was performing. Under the definition of live entertainment and the liquor board rules. Which is at subsection P. Live entertainment means any one or the more of the following. It says number 7, disc jockey. Live entertainment does not include adult entertainment. I'm sorry, I'm looking at the wrong place. In the city code, entertainment live means one or more of any of the following being performed live by one or more individuals, whether or not done for compensation or whether or not done for admission. It includes disc jockey, but it has to be a performance live. With regard to the loud music, I've said this and I'll say it again, that there should be some standard to this rules violation and not a subjective ad hoc measure that is being applied. It either has to be sound meters or a warning prior to issuing an actual violation, regardless of whether on another occasion it was felt or determined that the music was too loud. The standard that's being applied is extremely subjective, and it has to be tightened up in order to find someone guilty of a violation. It is conceded that some of these individuals had their mask down, and that was not allowed. I would, however, note that the applicable executive order that should be applied in this instance is not the mayor's executive order of March 12th, 2021, in that it was expressly preempted by the governor's order of March 9th, in which in section 1D and E, the governor indicated, subject to paragraph 1E below, if a political subdivision determines that doing so is necessary and reasonable to save lives or prevent exposure to COVID-19, the political subdivision is hereby authorized to issue orders that are more restrictive than this order. 1, requiring any business, organizations, establishments, or facilities to close or modify their operations. E, paragraph 1D shall cease to be effective at 5 p.m. on March 12, 2021, at which time all local orders issued pursuant to paragraph 1D above shall become null and void. Apparently, the mayor ignored that provision. Nonetheless, under the case of Wharton Creek Marina LLC versus Claggett, 381 Maryland 499, 2004, the Court of Appeals defined conflict preemption as follows. When a local government ordinance conflicts with a public general law enacted by the General Assembly, the local ordinance is preempted by the state law and is rendered invalid. Basically, the standard for conflict preemption is if something is allowed by a local law that is prohibited by a state law, or something is prohibited by a state law that is allowed by a local law, it is preempted. These are not ordinances, these are executive orders. The governor, through the Emergency Powers Act, is the person designated as the person to enact executive orders pursuant to a finding of a state of emergency. He is authorized to delegate local powers. He is authorized to take away that delegation, which he did in fact do. With that said, the governor's order, although it did away with the percentage occupancy limits, it still required that people be seated when they are served. It also required that they have masks on while they are not at their tables. There's no evidence about people being served while not seated. So it is conceded that some people had taken their mask down, and that shouldn't have happened. Finally, with all of that said, we are all living through this COVID and the various restrictions. They are changing weekly. It is confusing for the businesses. The businesses are just trying to stay open long enough to not end up in a permanent closure. And if the board does find my clients guilty of one or more of these three charges, I respectfully ask that you consider all of that and take that into mind. There have been 2 prior violations within recent history. Some of the charges in those prior violations were dismissed, but nonetheless, they did occur. But I respectfully ask the board, if they are going to find the clients guilty, to consider a fine. Thank you.
Okay, thank you.
Mr. Chairman, if I'll just may I be heard briefly on the matter of law?
You may.
All right, thank you. Just for council and for the board's understanding, the mayor's executive order of March 12th on page 2 in the first full paragraph, the mayor cites authority not deriving from the governor's executive order, but from the public safety article, section 14109, and various Baltimore City emergency operations plans that are submitted to the MEMA in accordance with state law. So I believe the mayor cited different authority for where he had his power to enact the restrictions he did. That is all, sir.
Okay, thank you. All right, on the basis of the materials contained in the charging documents and the testimony received, as well as the arguments of counsel, and Mr. Previs is always very creative in his arguments about these things, and I appreciate the fact that he looks very carefully at the charging documents and at the evidence in the case. I disagree with respect to him. I disagree with him with respect to the Rule 4.14 live entertainment violation on March 19 because I find that Agent Perez is credible when he describes the individual there working as a disc jockey on the premises, and then the individual other man coming up to him telling him that he had, I don't know if he said that he hired him, but he obviously had set up a birthday party at that time. And so I think there was a live entertainment violation, and there had been a previous one, as Agent Perez stated just back in February of 2021. So they were aware that that was not permissible. I also find violations of Rule 4.16 on March 19 and Rule 3.12 on March 19, and even putting aside the executive order violations, I disagree with Mr. Previs again about the need for anything other than subjective standards on the loud music, because when we get 311 complaints from neighboring places, and then when our agent arrives and he can hear the music before he gets inside, I think that's sufficient to sustain those violations. So I find all those violations occurred on March 19, 2021. And this record, it's interesting because they've had the license since 2005. They didn't start violating until 2014. Then they became fairly consistent. So they need to be much more careful. They are approaching a situation where we're going to have to be very tough. I take into consideration the climate in which all of this occurred with COVID. So I would impose $100 fines with respect to each of these 3 violations and give them 30 days to pay. Commissioners?
Commissioner Guy, based upon the evidence presented and the proffer of Mr. Previs, I would also too find in violation of Rule 4.14 live entertainment without authorization, violation of Rule 4.16 illegal conduct, and violation of Rule 3.12 general welfare, all taking place on March the 19th, 2021. And I concur with the fine of $100 for each offense payable in 30 days.
Based upon the charging document, the testimony, and the arguments from Mr. Previs, I too find a violation of Rule 4.14 on March 19th, 2021, and concur with the imposition of a $100 fine. I also find a violation of Rule 4.16 on March 19, 2021, and concur with the imposition of a $100 fine. And I find a violation of Rule 3.12 on March 19, 2021, and also concur with the imposition of a $100 fine.
Do we have public comment on this case, Mr. Blendy?
If any member of the public wishes to testify on this matter before the board, please use the raise your hand feature in the WebEx platform. Mr. Chairman, I do not see any member of the public who wishes to testify.
Okay, Ms. Russell, do we have exhibits?
Yes, might call exhibits for the record. Board Exhibit 1, Violation Report, Agent Perez, dated 3/19/2021. Exhibit number 2, Mayor Executive Order, dated 3/12/21. Exhibit number 3, Service Request Summary, dated 3/19/21. And exhibit number 4, BLLC Guidance, dated 3/12/21.
Thank you, everyone.
Thank you, Mr. Chairman, members of the board.
That concludes this matter before the board. Licensee will receive follow-up via mail with instructions on how to pay the fine. Mr. Chairman, is the
Thank you,
board
Mr.
ready
Yes.
for the next hearing?
Yes.
The third item on the docket for today is licensee Eleanor Katsouradis and Stephen K. Katsouradis Jr., Garden Bar, Inc., trading as Garden Bar. License is located at 4809-11 Erdman Avenue, 21205. Licensee holds a Class BD7 beer, wine, and liquor license and is alleged to have violated 2 rules stemming from the same date incident of March 13th, 2021, a violation of Rule 4.16 illegal conduct and a violation of Rule 3.12 general welfare. I believe Mr. Katsouradis, if I'm pronouncing his name correctly, is in the panel and unrepresented.
Yes, sir.
Okay. Mr. Katsouradis, are you there?
Yes, sir.
Can you make yourself visible?
There you go. Oh, wait a minute.
Sir, you're charged with 2 violations on March 13th. Are you going to admit them or deny them?
Admit them.
Okay, well, let's swear him in and so we can talk to him.
Okay, please raise your right hand. Do you solemnly swear or affirm that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury?
Yes, I do.
Thank you.
Thank you, Mr. Katz. Are we saying your name correctly, sir?
Yes, it's close enough. Katsouradis.
Okay. Do you want to tell us what happened on March 13th?
My manager was in charge of the bar that night. He let it get a little too many people, and it was his fault. It wasn't anybody else's. We had the different groups of organizations have been coming in all through the pandemic about 10 times. We've been complying about everything. He just let it a little too many people come in. After it was said and done, he closed up to just alleviate it. And fire marshal was telling him, everything was good. Appreciate your cooperating, and that's about it. I don't know what else to say. We've been in business actually, my parents had it prior to me, which has been since the 60s. We try to stay above everything, and it just, like I said, it was a mistake, and I'm sorry.
We appreciate that. Do the
Okay.
commissioners have any questions for Mr. Katsouradis?
I have no questions.
No questions.
Okay, thank you. Mr. Katsouradis, I appreciate your candor. I take note of the fact that you've had this license since 1978, and you've had only 2 violations in all that time.
Yes.
So I do think you're trying to do the right thing. And I understand your explanation. And you, I hope, understand that while your manager made the error, it all comes
It's my
back to you.
fault. I understand. Yes,
Yeah.
sir.
Okay. All right. On the basis then of the materials contained in the charging documents and the testimony received, as well as the admissions, I find violations of Rule 4.16 and Rule 3.12 on March 13, 2021. And in light of the circumstances and the record, I would impose $50 fines as to each and give the gentleman 30 days to pay.
Thank you very much.
Commissioner Guy, based upon the evidence presented and the testimony of Mr.
Katsouradis.
excuse me, pardon me for that, violation of Rule 4.16 illegal conduct and violation of Rule 3.12 general welfare, taking place on March 13th, 2021. I concur with the fine of $50 for each offense payable in 30 days.
Based upon the charging document, the testimony, and the admission, I too find a violation of Rule 4.16 on March 13, 2021, and concur with the imposition of a $50 fine. I also find a violation of Rule 3.12 on March 13, 2021, and concur with the imposition of a $50 fine.
Mr. Blendy, is there any member of the public who wants to comment?
If any member of the public wishes to testify on this matter before the board, please use the raise your hand feature in the WebEx platform. Mr. Chairman, I do not see any member of the public who wishes to testify.
Okay, with that, Ms. Russell, we have exhibits.
Yes, like close exhibits for the record, violation report. I'm sorry, exhibit number 1, violation report dated 4/30/21. Exhibit number 2, mayor's executive order dated 3/12/21. Exhibit number 3, BLLC guidance dated 3/12/21.
Thank you. Thank you, Mr. Katsourakis.
Thank you, sir. Thank you all.
That concludes this hearing before the board. Licensee will receive follow-up instructions in the mail with instructions on how to pay the fine.
Thank you. Have a great day.
Thank you.
You too.
Mr. Chairman, you ready for the fourth?
Yes.
The final item on today's docket is licensee Juliana McGuire, Sangria LLC, trading as Sangria, 930 North Charles Street, 21201. Licensee holds a Class B beer, wine, and liquor license and is alleged to have violated 2 rules dating from the same incident on March 4th, 2021, a violation of Rule 4.16 illegal conduct, and a violation of Rule 3.12 illegal conduct. Licensee is represented by Jeopardy superstar Justin Williams, and I believe he has one witness who is also impaneled now, sir, Mr. Chairman.
All right, Mr. Williams, will you identify yourself for the record, please?
Thank you. Good morning. For the record, Jeopardy third place finisher, Justin Williams. I'm from the law firm Rosenberg Martin Greenberg. I'm joined, I believe, in the panel, or he should be. See him on the list of people.
Is it Ricardo Jones?
Correct, Ricardo Jones. He is the majority owner of Sangria LLC and has been serving as the manager during COVID times. Ms. McGuire, licensee, is not available.
Mr. Williams, will these be admissions or denials?
Admission.
Okay. Do you want Mr. Jones to testify?
He shouldn't need to, but if you have
Okay.
questions.
Well, why don't you proffer?
Sure. Thank you. So yeah, so we can see, and I'm not sure you'll be able to see in my screen here, the photo of the establishment. As just mitigation, we can recognize they're in violation of the 25% indoor capacity rule based on fire rated capacity. I believe, just looking at the fire rated capacity number of, I believe, 90, it's low. And actually, Mr. Jones is looking into raising that to where it should be, because it seems like a fairly large establishment. And additionally, in the rear of the establishment is an outdoor area that could be confused as indoor by the agents, and some of the patrons were back here. And so while there were 80 people, give or take, we could see that number, there was more space than one might think. So it wasn't, I guess, an overcrowding issue here, we don't believe. And I guess also we noticed this mitigation that, even though it's not required, there was also no COVID warning issued prior to this. And then I guess the records in front of you. I think since they've been open since 2017, the establishment's only received 1 violation. That was in 2019 for not operational issues, but for a grease trap issue. And as you've heard, I'm sure in many cases these past few months, Sangria is facing challenges like every other operator. And so they're just able to resume to normal capacity after a year plus. So for those reasons, we request a modest fine.
Thank you. Do the commissioners have any questions for Mr. Williams?
I have no questions.
No questions.
So I have a question. When were you on Jeopardy?
My episode aired on Friday last week.
And who was the guest host?
Bill Whitaker from 60 Minutes.
Oh, okay. I must have missed that. I'm sorry. Well,
It's not your fault, but it went viral because I messed up the first clue on Benifer. So that's my shame and my penalty I'll have to live with for forever.
yeah, well, life is cruel. Okay. Mr. Williams, on the basis of the materials contained in the charging documents in your proffer on behalf of your client, including the admissions, I find violations of Rule 4.16 and Rule 3.12 on March 4, 2021. In light of the record and all the circumstances, I'd impose $50 fines as to each of those and give the client 30 days to pay. Commissioners?
Commissioner Guy, based upon the evidence presented and the proffer of Mr. Williams, I also too would find violation of Rule 4.16 illegal conduct and violation of Rule 3.12 illegal conduct, both taking place on March the 4th, 2021. I would concur with the fine of $50 for each offense payable in 30 days.
Based upon the charging documents, the proffers, and the admission, I too find a violation of Rule 4.16 on March 4th, 2021, and concur with the imposition of a $50 fine. I also find a violation of Rule 3.12 on March 4th, 2021, and concur with the imposition of a $50 fine.
Thank you. Mr. Blendy, do we have any members of the public who wish to testify?
If any member of the public wishes to testify on this matter, please use the raise your hand feature in the WebEx platform. Mr. Chairman, no member of the public wishes to testify.
Thank you. Ms. Russell, do we have exhibits?
Yes, like close exhibits for the record. Board Exhibit 1, Violation Report, Agent Perez. Board Exhibit 2, Mayor's Executive Order dated 2/22/21. And Exhibit number 3, BLLC Guidance dated 2/22/21.
Okay, Mr. Williams, thank you. Hope you get another shot at Jeopardy.
Or another game show at least.
Right.
Thank you.
That concludes this matter before the board. Licensee will receive follow-up via mail with instructions on how to pay the fine. Mr. Chairman, that concludes all matters on the docket before the board today. If you're prepared, I'm ready to read the adjournment.
Go ahead, please.
The board will be in recess until Thursday, June 10th, 2021. The board shall post it on its website, provide notice to the applicants and/or attorneys, and conduct a virtual hearing on this date. Please call our office at 410-396-4377 between 8:30 a.m. and 4:30 p.m. with any questions or concerns that you have concerning this or any other matter. That concludes everything before the board today, Mr. Chairman. So the board will be in recess until June 10th at your order.
Yes, thank you. Commissioners, thank you. Liquor Board staff, Mr. Blendy, Kim, Ms. Russell, thank you all. Hope everyone has a nice day, and we'll see you on June 10th.
Do the same.
Thank you.
Have a good day.